Right. Well, first of all, can I welcome everyone to the fourth Red Lion Chambers webinar in the 2022 program. The title of the webinar is How the Past Comes Back to Haunt You. And in fact, as we'll see in one case, the future can come back to haunt you. And it's an update on evidence relating to bad character, presented by myself and Bethan Rogers. Can I also thank our pupil, Grace Hale, who is dealing with the IT, and also for all the help that Felicity has given us in preparing this presentation. There is a facility for written questions. If anybody has a question, please use the Q&A tab at the bottom and write your questions. And at the end of our presentation, hopefully there will be some time to answer some of those questions. So off we go. Now, I'm going to start with Section 100 of the Criminal Justice Act 2003. As everyone I'm sure will remember, this relates to non-defendants' bad character. And Section 100B of the Criminal Justice Act says this: it's got to have substantial probative value in relation to a matter which is a matter in issue in the proceedings and is of substantial importance in the context of the case as a whole. Now, I'm going to begin by talking about a case that I was in November because the decision is perhaps slightly counterintuitive. The case, or the facts of the case, were simply these. SD, who was the defendant, armed with a knife, went round to the address of the deceased's girlfriend. The deceased then ran out of the house waving an 8-inch knife, which he then proceeded to use, prodding towards the defendant. The defendant said that in self-defense, he stabbed the deceased once in the chest. The defense wanted to adduce a number of pieces of evidence relating to the character of the deceased. The deceased was 16 and had no previous convictions. The first matter they wished to adduce was a photograph of the deceased holding a machete at home that had gone up on social media. They also wanted to adduce a number of rumors and crime reports which suggested that the deceased used knives. The judge ruled that the evidence was not admissible because there was no matter in issue in relation to the knife. Given that the prosecution accepted that the deceased ran out of the house with an 8-inch knife and was the initial aggressor, the judge found that the evidence was not admissible. On the slide, you see, I say that it's awaiting permission to appeal. I should say that a couple of days ago, the single judge has refused permission. There are two, in my view, very important cases to keep in your back pocket as far as Section 100 is concerned. Surprisingly, in my experience, a number of members of the bar are not familiar with them. They are old, they're now 12 years old, but they are both terribly important. The first one is Braithwaite, and we've got the reference up there. And that relates to the nature of the material you're trying to adduce. mere allegations are almost never admissible. Inevitably, only convictions or cautions. And Braithwaite is a case, Lord Justice Hughes, as he then was, and it relates both to Section 100 and Section 101 of the CJA, so non-defendant's character and defendant's character. And then the second case that you need to have in your back pocket is a case called Brewster, 2010, and it deals with cross-examining witnesses as to credibility. Some of you may remember that one of the purposes of Section 100 of the Criminal Justice Act was to stop defence counsel just throwing convictions at prosecution witnesses. Now, Brewster says that credibility can be something of substantial probative value and can be of substantial importance in the context of the case as a whole. And so the court, before deciding whether to allow counsel to cross-examine a witness, either a defence witness or a prosecution witness, as to their previous bad character, has to consider two matters. First of all, the importance of the evidence given by the witness in the context of the case. So a simple example that I had recently was cross-examining an alibi witness. Clearly, alibi evidence was important in the context of the case and related to a matter in issue. And then the character itself, the test is whether the bad character evidence is reasonably capable of assisting a fair-minded jury to reach a view whether the witness's evidence is or is not worthy of belief. And the convictions do not have to be for offences of dishonesty.
Case of Arm, I hope I'm pronouncing that right. The reason I wanted to include this is because it's a fairly recent case, and it was an appeal on how, well, the issue that was dealt with by the Court of Appeal was how a court should approach material adduced under Section 98. Should they take the same approach as they do with bad character? Should there be a direction? And in the case of Arm, there was no direction whatsoever in relation to material that was put before the judge. As you can see, it was an appeal against a conviction for rape, and the prosecution put before the court reprehensible behaviour under Section 98 in relation to controlling and coercive behaviour that had predated the allegation. There was no dispute from either side that this was material that should go in under Section 98. The sole issue being raised at appeal was the fact that the judge had failed to give any kind of direction as to how that material should be approached by the jury. And both parties again accepted that there should have been a direction, the only difference being that the prosecution said it didn't make the conviction unsafe. What the Court of Appeal said on this occasion is that, and they referenced quite a useful case that I've put down there called RVMA. They also referenced another case, a bit older, that perhaps I should have put on the slide, RVRJ. It's a 2017 case. And what was said there was that the court should have in mind the safeguards attached to bad character evidence when considering Section 98. They should consider appropriate directions to the jury to use regarding what use they should put that material to, and if appropriate, what weight should be attached. They then refer to RVMA, which is more useful because at that point they said, right, well, when material goes in before under Section 98, Court of Appeal say the sort of route that a judge should take is, number one, identify to the jury what evidence you're talking about. Number two, in the usual fashion, say to them, well, if you're not sure of the truth of this material, discard it. Thirdly, tell them that this portion of the evidence, however admitted, isn't direct proof of guilt. And then fourthly, tell the jury, well, if you are sure of this evidence, what can it show? For example, in this case, it doesn't show that the defendant was guilty of rape, but arguably it could go to the issue of whether or not he reasonably believed the complainant consented, because clearly prosecution is saying here, with a history of coercive and controlling behaviour, the issue of what respect he shows to someone's lack of consent is up for grabs. So the reason I wanted this slide included, or this case included, sorry, is that we have a tendency, or I have a tendency certainly, to think of Section 98 as being out there and wholly separate, when in reality, if this material is going before a jury, the defendant is entitled to some form of direction which requires the same sort of safeguards as a jury would have in relation to bad character evidence. Anyway, despite all of that, as per usual, the appeal was dismissed. Grace, I think that's, did I put anything else in relation to that? Next slide. Oh, sorry. I mean, that's basically the list I just went through now. Back to you, Jeremy.
I'm now going to talk about gang evidence, which is becoming more and more common in my experience. And I'm going to deal with two cases, one called Dixon Keating, which is a 2021 case, and then a follow-up case where the judgment was handed down last month. The facts of Dixon Keating were that he was convicted of murder of again, young man, Solomon Small. The killing took place in Brixton in August of 2019. He was stabbed with a kitchen knife, all too common these days. There were 5 other stab wounds. There were defense injuries to the arms. He surrendered to the police 5 days after the incident was identified by eyewitnesses. When interviewed, he made no comment. Just before the trial, the prosecution served evidence from a police officer, a police constable Barr, who has great experience of South London gangs. And the evidence supported the contention that the defendant and the deceased were members of rival gangs. There was also evidence adduced of other individuals' affiliations with gangs. And despite defense objections, the judge ruled the evidence was admissible. Grace, please. The defendant had no previous convictions and denied that he was a member of a gang. He said he was acting in self-defense, fearing an attack upon him by S and members of S's gang, and alternatively, he lacked intent or lost control. Leave to appeal was given on 2 grounds. First of all, that PC Barr was not an expert and his evidence ought not to have been admitted, and the motive, namely that it was gang related, was not sufficiently supported by admissible evidence. It wasn't put to the defendant in cross-examination and was not accompanied by the appropriate level of disclosure. Next slide, please, Grace. The court found that PC Barr was undoubtedly an expert. I don't know whether any of you have had experience of his evidence. I have. He is very familiar with South London gangs and the various rivalries between them. He also is a fan of drill music and is able to translate the lyrics extremely well. But the court said that one has to be careful. Disagreements may arise when an expert moves from the general to the particular. And what they said was it did not follow from PC Barr's undoubted expertise in Lambeth gangs that he is entitled to assert without more that X or Y was a member of a particular or any gang. That opinion would have to be based on admissible evidence, which could be tested in the usual way, and which also satisfied the requirements of the Criminal Justice Act. They found No surprise that gang evidence was admissible to prove motive following a case called Myers in 2016. And there is also a case called Awayemi, which reviewed the previous authorities as to the relevance of gang evidence in certain situations. Please, Grace. Thank you. This is the case where judgment was handed down last month. Similar set of facts, but it took place in Coventry. There was no dispute that the perpetrators were guilty of murder. The issue was a case of identity. Prosecution case was that the murder was gang related. The prosecution were given leave to call evidence from a local officer who explained the history of the two gangs allegedly involved in the incident. The officer was not permitted to give evidence of gang affiliation based on hearsay material. Such proof required direct admissible evidence. The other gang evidence that was adduced related to the defendant associating with the RB7 gang, the gang in question in drill music videos, the defendant being shot twice and not cooperating with the police, the deceased living in the opposing gang's postcode, and the shouting of the words "it RB7" at the time of the killing was admissible under res gestae. The grounds of appeal were that there was no proper evidence of gang rivalry in Coventry, which manifested itself in serious violence, and that there was no clear evidence that the stabbings were gang related. Yes, great. It was accepted in the Court of Appeal that appearance in videos and the use in those videos of violent lyrics should not automatically lead to the conclusion that someone is a gang member. And then to quote William Davis, LJ, but that is not the same as saying that they cannot lead to that conclusion. So long as appropriate caution is advised by the judge, which had occurred in that case, a jury is entitled to consider such material. If there was an alternative explanation for the defendant's appearance in the videos, he did not choose to give it. And in relation to the videos, Court of Appeal was satisfied that they provided an evidential foundation for proving that the defendant was associated with the RB7 gang. Thank you, Grace. And this is perhaps an interesting aspect. The court also confirmed that the evidence of A having been shot and refusal to disclose any details of the incidents or to make witness statements was admissible, and that evidence occurring after the incident that was on trial could be evidence to do with the facts of the offence. So namely, evidence of gang membership subsequent to the offence could, in certain circumstances, be admissible as to whether the defendant was a member of the gang at the time of the offence. And the Court of Appeal found that these were probative of the defendant's involvement in gang-related violence. Yes, Chris. And so a brief summary: gang evidence is not admissible unless it's relevant to an issue in the case. Even if the evidence is relevant, it would be excluded if its prejudicial effect outweighed its probative value. Evidence of motive for an offence always will be relevant and can be adduced under Section 98. So in other words, if it's tit for tat violence between gangs, that would be evidence of motive. Gang evidence in relation to an individual may be relevant where identity is an issue. Gang evidence can be admissible, as to do with the alleged facts of the offence or as bad character evidence via section 101(1)(d) or via both routes. But whichever route was taken, the judge is required to consider whether admitting the evidence would have had such an adverse effect on the fairness of the proceedings that it should not be admitted. Thank you, Grace.
Right, this one's back to me. This isn't particularly groundbreaking in the way Dixon Keating has the potential to be. The reason why I wanted this one included is that, as I say at the top, it's notable for the fact that it shows the variety of sources that bad character evidence can come from. In this instance, the defendant had been convicted of murder and he accepted causing the injury, but asserted he'd been acting in proportionate self-defense. In order to rebut that defense, the Crown sought admission of his medical records. He had been sectioned for a period of time, about 4 years prior to the incident. And these medical records showed this young man was prone to violent outbursts. And the prosecution said he was more likely to be the aggressor in a fight, more likely to seek to engineer a violent confrontation, and therefore, of course, relevant to a matter and issue. Agreed facts went before the jury, which included the series of incidents that had occurred when this defendant was in hospital. The appeal was brought on 2 grounds. First of all, as you can see there, that the judge had been wrong to admit the defendant's medical records that had been in breach of the Data Protection Act. But the Court of Appeal dealt with that very quickly and said, no, absolutely fine, crack on. Then, perhaps more importantly, that he shouldn't have allowed such material to be used, unduly prejudicial, and ought to have been excluded under section 101(3), which, as you may or may not be aware, is the safeguard that hangs over any application to adduce material either under Gateway D or G, because it may have such an adverse effect on the fairness of proceedings. The court ought not to admit it. Court of Appeal found that the evidence about his behaviour in 2017 can only be used if it was able to provide some support. And the question that has to be asked is, was this evidence relevant? Well, the Court of Appeal rather dryly pointed out a key issue for the jury in this instance was, why did the defendant stab the deceased 5 times in the street? And clearly, if someone has a tendency towards or propensity towards violent outbursts and an inability, self-reported inability to control his temper, arguably that is relevant in the case of this nature. So it's worth remembering this one. It's not particularly exciting, as I say, but it does go to show that the source of material to adduce bad character evidence from doesn't always have to be convictions. As you can see, yet again, dismiss that appeal. Now this one, RV Hussein, I got quite excited about this one because it deals with 2 points, both a section 100 application and a bad character application. Having said that, going back over it, it's fairly fact specific, so I may have got excited without any good reason, so apologies if that's true. Anyway, RV Hussein, this related to a case where there had been a long-standing issue between the defendant and the opposing family, the Shahs, and in this occasion the defendant had been convicted of affray, section 18, wounding with intent, and the complainant was a member of the opposing family, the Shahs. He was identified by Imran Shah and his brother, and the defendant said, no, this is a false and indeed malicious identification. So of course the background is relevant because they have every reason to want to get me. The Crown had opened that there was this history of violence and animosity between these families, and they described it as tit for tat. And of course, as I say, the central issue was one of identification. So when it comes to the grounds of appeal, firstly, the judge had allowed in one of the complainant's previous convictions, which was a conviction for perverting the course of justice. Defence appealed firstly on this ground that he had erred, or she had erred in doing so, because there were other previous convictions which also ought to have gone in. Grace, can I get the next slide, please? second ground was that the judge had further erred by only allowing in that one previous conviction for the complainant, but allowing in all the defendant's previous convictions under Gateway G, namely that there had been an attack on character. So it was suggested that there was an overall imbalance, because on the one hand, you're only allowing in this one previous conviction for perverting, but on the other hand, when it comes to the defendant, you're allowing in everything, which was unfair when one has regard to the very limited extent to which the defence were permitted to attack Imran Shah's character. I've mentioned there the case of Brewster and Cromwell. That was, I mean, one of the things that I find quite useful when they have these new cases is because the Court of Appeal obviously go back over old cases. So you end up down quite a helpful rabbit hole as to what the tests are that should be applied in these circumstances. Brewster and Cromwell said that when you are looking at Section 100, and I think Jeremy's already mentioned this, but the misconduct relied upon must be reasonably capable of assisting a fair-minded jury to reach a view on whether the evidence of the witness is or is not worthy of belief. Now, in this instance, Mr. Shah had previous convictions for threatening words and behaviour that was connected to this family feud that I previously mentioned. He also had previous for handling stolen goods. And of course, those are dishonesty convictions. And the Court of Appeal felt that they should have allowed in all of the convictions because, again, I think I've made reference to the case of Clark there. That's a 2011 case. Judge can admit evidence which tends in a general sense to damage the character of a individual to allow the jury to assess the respective merits of the accounts given by the complainant and the defendant. Now, ultimately, they found that there was a ground of appeal and they allowed it in relation to that first instance, should the precons of the complainant have gone in under Section 100. They didn't find that there was this imbalance, however, but as a consequence of allowing the appeal in relation to Section 100, this matter has been referred back for a retrial.
This case, Kelsey Rogers, facts, it's another single stab wound to the heart. The defendant, 17 years old, became involved with an argument with the deceased who was 16, and the deceased suffered a single stab wound to his heart. This all took place in a closed environment. The defences run by the defendant were accident, self-defence, and/or lack of intent. The defence applied successfully in part to adduce evidence of previous aggressive behaviour by the deceased under Section 101 1B. The prosecution that should be 101B. The prosecution then successfully applied to adduce 2 previous convictions for robbery when the defendant was when the defendant was 15 under Section 101 1G. And just to remind everyone, 101 1G is the tit for tat provisions. Counsel had a rather ingenious argument. I say that, in fact, it was an ex-pupil of mine, but the Court of Appeal, as you will discover, didn't think it was that ingenious. Although counsel in the case accepted that Section 101(1)G, namely the tit for tat provisions, had been engaged, she argued that as the bad character admitted related to the deceased, these bad characters should not be admitted, as the deceased's credibility was not in issue. In other words, of course, the deceased wasn't there to give evidence. Counsel argued that the prosecution had not applied to deduce the material under section 101, subsection D, namely propensity, indicating either a propensity to commit violence or untruthfulness. And thus the evidence of the defendant, the applicant in the case, bad character, should only have been admitted if it could provide the jury with material on which they could form their judgment as to whether the applicant was any more worthy of belief than the person whose character he had attacked. That means, counsel submitted, that the only legitimate purpose of admitting evidence of the applicant's bad character would be to assist the jury to make a comparative analysis. Next slide, please, Grace. Thank you. Court of Appeal was having none of it. They found that where evidence is admitted through Gateway G, it is admitted because it is relevant to the general credit of the defendant, and its purpose is to show that the defendant's evidence is not worthy of belief. Where there is a conflict of evidence between the defendant and a prosecution witness whose character he has attacked, then evidence of the defendant's bad character will be relevant to the jury's assessment of the credibility of the defendant in relation to that conflict. But it does not follow that the evidence can only be admissible for the purpose of making precisely that kind of comparison. The well-established principle that the gateway may be opened where the attack is on the character of a deceased person is inconsistent with the limitation for which counsel contends. And so the Court of Appeal were saying, well, counsel can't simply attack the character of a deceased and then claim, well, you can't put in my character under the tit-for-tat provisions because the deceased is not giving evidence. The Court of Appeal made it clear that it was still relevant to the defendant's evidence, and the jury weren't being asked, in effect, to weigh up the two witnesses. Questions? Right, well, if there aren't any more questions, I'll wrap up the session. Can I thank everybody for attending? I hope you found it useful and also thought-provoking, because as we know, there are an infinite number of factual situations to try and apply these provisions. Can I thank Grace and Felicity again for their assistance in making this webinar possible? And can I also suggest to everyone that they look at our website for the next webinar in this series. Thank you very much indeed.
Thank you, everyone.